I would like to welcome David Hodson today, who's joining our In Conversation With series. And David and I met many years ago through the AFCC, which is a US organization, the Association of Family and Conciliation Courts. And they have sort of annual events where people from all around the world come that are involved with families, the courts, mediation, the administrators. And so new research is presented on, and at one of these events David and I first met, and we've kept the connection going over the years, and we are coming at this space, I think, in a very similar way. Both of us are hungry for new information. We're always looking for, how can we do this better? How do we bring family mediation in particular more to the forefront, and not just on the national level and international level?
Yes.
And who's doing what and where and why, and let's learn from one another. So I think we're very similar in our outlook. You are many years ahead of me in terms of your achievements and credibilities. Well, no, your achievements are outstanding. So I first want to give a slight overview, snapshot of David, if I may. So you're actually Professor David Hodson. You have an OBE, which is a recognition of the contribution you've made to family law and reform of family law in the UK. You're a co-founder partner of the International Family Law Group, which is a firm that specializes in international family law. You are an English solicitor, a mediator, an arbitrator. You're also an Australian solicitor and a deputy part-time family court judge at the Central Family Court in London and Western Circuit. You are a regular speaker. You're also an academic. So, your views are very much valued around the world, and the work that you've done is very much valued. And you have written the LexisNexis textbook, the International Family Law Practice, sixth edition. There we go. And I believe that's the edition you gave me. And I have to say that I've gone back to it many times, which is really interesting, because even though I'm a mediator, understanding the international context around family law is incredibly important. And there was some fundamental tips you gave there that we're going to talk through as we go through this session.
I hope so. Yeah.
So welcome, David. That's the opening.
Thank you very much. Delighted to be with you. Delighted to see you again. Far too long. It
has been far too long. I agree. So I'm going to start off by asking you a little bit of a background question about yourself in terms of your pathway to mediation. Then we're going to move to the much bigger, meatier piece of what I want to tackle with you today, which is the international stage and family mediation. So I want to begin with you. I think I may have this correct, that you began your path training as a legal professional. So you were a solicitor first, I think.
Yes, and I think that's crucially important, because our professions of origin, if I can call it that, sounds like a bit like domicile. Our professions of origin, I do think, dictate or inform how we regard mediation and how we regard practice and policy and things like that, and where we come from. And it can sometimes put up barriers, but I'd like to think it can also produce innovations as we learn from our professions of origin, if I can keep coming back to that, whether that's an academic or a lawyer, social worker, child therapist, or whatever. We can bring so much to mediation because we're not just coming, as it were, into one profession from an academic training or university or whatever. So yes, you say I'm an academic, that's more by and by. I'm a lawyer. I'm an English solicitor. That's my primary job. It pays the rent, so to speak. And I started in the provinces, had a time in central London, big city law firms. I then moved to a practice which was specifically to combine mediators, lawyers and counsellors. And it was only at that stage, I must have been about 20 years qualified, that I then became a mediator. And so I came to it very much from being a solicitor already. After that, I became an arbitrator. And so I've brought the two parts together. And one of the interesting things is, where does mediation and arbitration overlap, and how can we join the two together, particularly in the international? And primarily my work has been international law. And so when I became a mediator, I obviously concentrated on how do I do it and how do we help the international community.
And you've touched on something very interesting that we're going to deal with tomorrow in tomorrow's presentation, which is MedArb, Med. or whatever way we want to mix it up. But Colin Brannigan we're speaking to tomorrow, and he's a Canadian mediator and arbitrator, and he's doing MCIArb. So
you would only invite a Canadian to speak on the topic, because they are the evangelists. They have gone out from the equivalent of Jerusalem into all the ends of the world saying, do look at our lovely MCIArb. And in England, we've mostly rejected it. So I shall leave that for tomorrow, but we reject it because we think it confuses the roles. We don't think a mediator who has got privileged material can then so divorce themselves and become an arbitrator. And we have Canadians come and visit us in London and then say, yes, you can. And if they can, why can't we? But anyway, that's for tomorrow.
And it is, and but this is part of this conversation about what are we doing? How are we doing it? How are we doing it internationally? What is the consistency across different jurisdictions? So, and that actually neatly takes me to the key question that I'd like to address with you, which is, how are we going to take family mediation beyond our national borders? So to do that, because you gave me a wonderful PowerPoint presentation. You did a presentation to the World Congress. Was it earlier this year?
Last year.
Last year, okay. And you also have a chapter coming out in an international family law textbook for academics. So you're writing a chapter. You know, you're pushing. You're doing what you can do to push this.
I want to, Rosanne, because we've got to do this. We've got the example of the collaborative professionals, okay, based in America, and they have all the American resources, but they have a global organization behind them. We have the International Academy of Family Lawyers, the leading organization of lawyers doing international law. We have arbitrators, admittedly not yet in family law, but in civil arbitration, coming together globally. And yet we have almost nothing, I think I probably dare say nothing, almost nothing in the mediation context. So if I need to find a mediator in Dublin and I'm engaged in a matter with an Irish law, etc., how am I going to find one? If I do find one, well, of course, you know, I should come to you, Rossa, but apart from that, if I do find one, I go through sort of the internet, etc. How do I know what ethical standards they're working from? How do I know the way in which they work? Are they doing a joint mediation model? How do they actually work if they're doing it online? What sort of documents? Crucially, when they come out of mediation and they say, we've reached an agreement, isn't this wonderful? Is that open or is it privileged? Now, in the common law world, so much of the international world is common law, civil law, etc. In the common law world, we are almost always saying it's privileged. It's got to go off to a lawyer. It's got to be blessed by a lawyer. Say, yes, I'm willing to make it open. In the civil law world, which is primarily the EU and countries, it's immediately enforceable. It's an open document. So we've got to understand, Ross, how are we all operating? And now it's easier if I'm a lawyer and I go to a lawyer in America, by and large, I know how they're going to do their preparation for court. As far as mediation is concerned, we are still at first base because we haven't yet, and more crucially, we don't know what's best for international families. You and I have got a purely national case, and we can probably guess: is it joint mediation? Is it caucusing, shuttle, whatever? Is it directive? All the different phrases we use. If you've got an international case, what's best? We haven't done any studies or research, so we've got a long way to go. So forgive me. I've got a little note here saying, "Shut up! Don't talk too much."
No, I want the flow from you. This is what's really important. So what's interesting from my perspective is when I was reading all the material that you sent me for today, I just thought this is absolutely fascinating because we're working in parallel to one another. We're doing things in parallel to one another and hitting the same questions. Like, since you gave me that book, one of the first things that is at the forefront of the book was in relation, it's mainly about family law, but you did have a section in there about mediation as well.
Oh, yes.
And not long after you gave me the book, I hit my first international case where there was one party residing in Ireland, but the other one I think was in New Zealand, as far as I remember. And I went to your book straight away, and you had some key little tips in there that I've used since then because I've been getting more and more international work. So the first thing was, where's the jurisdiction of the mediation? That was my first question. Yeah. So in the intervening years since I've last spoken to you, we now have the Mediation Act 2017 has commenced in Ireland, which commenced in January 2018. And it now gives us a section 10 on confidentiality. So we have that privilege piece, we have the confidentiality piece around what the mediation piece. So I make the jurisdiction Ireland for the mediation. Just bear with me for a moment, because I've been teasing this out, trying to figure the way through this, right? So because we have an agreement to mediate under section 7, and so I make the jurisdiction of the agreement to mediate Ireland. Then I have the parties tell me where's the jurisdiction of where's the agreement going for enforcement purposes.
Yep.
So you know, they then agree that piece, and my third piece is where are the children, if there are children, and where have they been residing, and so I look for those pieces, because your book set that out for me, which was brilliant, because it helped me think about what are these key pieces, because the parties coming to you, they just see themselves as a family. It doesn't matter if they're 3 countries apart from each other. They just see themselves as a family, and they want the solution to be brought to them.
Yeah. It was really talking to national mediators to say, you may not have done an international case before. These are key questions to ask. Where's the child? Is the child safe? Before I start mediation, let's know at least which country they're in. Where are the assets? Are the assets secured? But then coming on to your question, what's where are the proceedings going to be? By which I mean not the law, but the country. Are they going to be in, excuse me, using your example, in Dublin or in Christchurch? Once you work that out, probably which law will follow. But if you're involved in the EU, that may not be so. It's the applicable law. So that's, if I may say, relatively basic for a national mediator, but because national mediators get no training in dealing with international cases, I would then want to go on to say, right, you've got an experienced mediator and they are approached as, in your case, is it Ireland or is it New Zealand? And I would say, how can we push some boundaries there and say, yes, this is a Irish mediation. I'm in Dublin. I'm doing it here. If I need to sue you for my fees, I'll do it under Irish law, etc. But I wonder, given that you can't agree whether the proceedings should be in Ireland or in New Zealand, you've got a forum dispute going in parallel there. I wonder if we can reach an agreement that actually satisfies you, the couple, and actually is vaguely within the proximity of Ireland and New Zealand. And here's the benefit of having some knowledge of international law, alternatively having what I call the joint mediation model, where you have a mediator in Ireland, a mediator in New Zealand, who both know their local laws, and they try and find a way through for the couple that actually satisfies it without having this huge horrid costs of a forum dispute. Now, this is pushing a boundary quite some way, but this is already going on with lawyers. Lawyers are, we have an England America case, and we call it a transatlantic settlement. It's somewhere in the middle of the Atlantic, could be an Irish Sea settlement, etc. And I wonder if in mediation, and I'm certain, I wonder, but I'm certain, I know that's where mediators will go. But you've got to be fairly experienced, fairly confident. And I'm not sure whether, I don't think I would do an English-Irish mediation, because I don't know my Irish law well enough. I'd probably be saying, hey, Rosin, can you and I do it together and actually help the couple? But that then, if you've got one person in one country and one in another, you can combine that by actually having a digital mediation, online mediation, and one person sits with the other. So you've got the physical presence, not representing, but they say, well, hang on, if it were in Ireland, this is what would happen to the assets. If we were in New Zealand, this is what happened. Now, where do we go from there? Because mediation is owned by the couple, is not owned by the lawyers, which is what happens in a forum dispute, is owned by the lawyers or one of the 2 judges.
So I think there's a couple of pieces in there that are probably very much of now, if you like. So the digital space. So COVID came and our world changed. So as a mediator, pre-COVID, the only online work I had done were there was geographical distance. So for not necessarily the 2 parties could have been residing in Ireland, but one of them could be away in Abu Dhabi or something doing some work. So that was so it was, I think it was Skype we were using. And so COVID came and a whole new world came into being, and all of my work moved online. I'm completely comfortable now with working online.
Everyone.
Probably too much so. I kind of want to stay there. But it's so the technology, the understanding of technology, mediators had to quickly learn, or they were gone.
Agreed.
They weren't working, right?
Yep.
So okay, so we've all got this technology reasonable competence level now. The next piece then is, there's a big difference between knowing that Roisin O'Shea in Ireland has some experience of this, I'll go and find her, to having standards that we all agree that we as mediators will apply wherever where it's international. So then we look at what has been done in relation to mediation to do with these issues. So we've got the EU Directive on Cross-Border Mediation, and we have the Singapore Convention, but neither of them.
Yes,
neither of those deal with what we need to deal with.
The Singapore Convention specifically excludes family law. Huge frustration. I got in touch with them and said, guys, before you actually sign off on it, it was about 3 years ago, can you add an extra clause? And by the way, this also includes family. And they said, oh no, deliberately no. It was done by a commercial group within the United Nations, which was behind it. And as I understand it from them, if we want a Singapore mediation convention, we've got to do our own rather than tacking it on to that one. And why should we? Why can't we do something like the EU mediation directive in a more collaborative fashion?
I would be absolutely behind you on that.
The Dublin Convention's what Russ said.
Let's call it the Dublin Convention. See, I think what's going to come out of this week, this is International Mediation Awareness Week 2022, because obviously somebody watching this in a year's time needs to know where is this conversation placed in time. And I think there is great potential for the speakers that we've invited this week to put our heads together and begin this work, because what I really liked was your call to action basically in the World Congress PowerPoint that you did, because you're not only looking at what's happening, what are the issues, what's happening, nothing, not enough, or nothing really, like if we look at it really honestly. And we don't have international codes or what are the models, how are things enforced, none of these things. Ireland, I have to say, I love the fact that we've taken this big jump forward with the Mediation Act, because when you and I spoke in London, oh gosh, it was
quite a few years ago, you were drafting it, I remember.
Yeah, I was drafting a code, and we were putting pieces into the Mediation Act. That's absolutely right. And there was an English judge that was there that you were sitting talking to, who also spoke to me. Gosh, I can't think of his name now. A senior family law judge I think he's recently retired.
Okay.
Anyway, his name will come to me later. But the thing is, this international piece has been moving anyway. We've been talking to one another, so I think we need to actually take this bull by the horns and actually step up and say, what do we need to do here?
I agree. And I think we know who the players are, always keen to know more. We do know there are some organizations are really going ahead with the training. There's an organization in Germany, MIKK, primarily child abduction mediation, which is fascinating, because that's the one we said is the real impossible. That's the hard nut. You really can't do that. And actually, curiously, they're the ones who have gone ahead, and it's the rest of us who are trying to catch up with them. So they're doing some great training. Melissa Kinski in Washington, she has done a lot of work. I sat on a committee with her involving a number of other mediators, trying to find a way for, admittedly, an American organization looking at a code of practice. And so the work is being done. I think in Switzerland, there's a charter that's been written by International Social Services. Again, hasn't made too much progress, but they're all there waiting, as it were, to find a way that we can bring it all together.
And you see, one of the things you spoke about earlier does bother me about the mediation space. And I think we need to be honest about this. Whatever about the international space, we haven't actually at national level agreed with one another as mediators what we are doing. Who are we? What are we doing? What is the work that we're doing? We don't yet have, I've actually just finished a survey of all of the member states. Sorry, you guys aren't in there anymore. So I did all the member states, and I looked at England and Wales, and I was looking at, is there anything like a mediation council in each of the member states and England and Wales? Where there is, how did it come into being and what is it doing? And then when I really looked at England and Wales, I saw all of these difficulties, all the tensions that I became aware of during my PhD, which you and I have spoken about. And it's the tensions between the very older professions, which we spoke about at the beginning, which is the legal professions, and then this growing space of mediation, which, let's call a spade, it is taking work away from lawyers, or at least that's how they're viewing it. And that creates this kind of difficulty about really, because we have to work together. We have to work with the lawyers. So I think we've got a job at national level to get our houses in order to get this conversation about consistency across international borders, So I think there's a good bit of work to be done, but maybe it could come top down, because if
Well,
we try and
I agree. I don't think we should wait until our domestic houses are in order and everything's perfect hunky-dory to moving on with this. As you say, maybe we'll just gloss over the historic frictions of lawyer and non-lawyer mediators and things like that. Gloss over that for the sake of the international families who don't care a toss.
And you see, there is the key thing. I had a conversation with the professor in Romania during that research I was doing recently. And he was saying to me that one of the things that always struck him was that mediators start telling potential clients about what mediation is and all that wonderful language about confidentiality, voluntariness, and all the rest of it. And he said, really, the clients don't want to know. They want to know what they can do in mediation. Can you provide a pathway to a solution for this issue? So we know that international families are growing. We know that they have a need to resolve their coming apart, so the breakdown of relationships or marriage. They need to do it cost effectively and quickly. And I don't think most people want to go to battle in courtrooms anymore. No. I think they get it, that it's not the right place for them and their family.
And forum disputes are far longer and more costly and more problematical than a purely national one. Partly because the first thing you've got to do is work out in which country the dispute will be. Once you've litigated over that, and in some countries that could take several years, you're no further forward in actually deciding what the outcome will be. It's tragic.
I saw that in your PowerPoint. I thought that was a really key point that you made, that your initial litigation may decide the forum, but it certainly doesn't decide the outcome.
Yeah.
So engaging in litigation is actually a sign that you've lost your way for a family, because you could actually go through the whole childhood of children while you're trying to resolve the issues. And I think the difficulty is that international families, for example, I'll give you an example. We have a case that has just come to us, and both parties live in Dubai. So I went, ooh, can we do back to David's book? Back to the front of your book. And I don't have that ability to reach out to a mediator in Dubai. I haven't thought that process through. So what I had to do was get up to speed with the law of the land in the Emirates. So,
well, I would simply go to a leading international family lawyer in the country concerned and say, who are the mediators you know? Until we've got a good list of reliable, accredited, branded mediators, yes, I would always say, go to a leading international lawyer in that country and say, who do you know, who's good, who does what particular form of mediation?
And I think that network is the piece that we have to build. Yeah. Because what I had to do is what I don't want mediators to have to do. I had to get up to speed with the law. So I did find a really interesting civil code, and I found that non-Muslim, non-nationals can come to their own agreement wheresoever, howsoever, and it can get ruled, like basically brought to their court and turned into a divorce. So, but you're right. We don't want. I need to do that groundwork because I want to understand how it's going to be. But I think if we have experienced mediators across the world that we know have hit a certain standard, what we have to agree what that is, and have certain experience levels, and then operate by agreed codes though as well, because it's not enough that we have national codes that they might be adhering to. We need international codes.
But I'm not trying to be simplistic. That's the sort of thing that certain sort of people can beaver away through on sending emails, etc. Somebody picks up a national code and they say, right, what do we change for an international dimension? Half a dozen people beavering away, surely in 4 or 5 months, famous last words, they can come up with something that should be workable. And this is a work in progress that we then work and improve upon. It can't be too long. We love the Americans so much, but they do produce relatively longer documents. Some might allegedly say. Some of us equally tend to use Latin and things like that. So we've all got our foibles, but together we should be able to iron them out.
So let's do a hit list of what we would like to happen next. That's the first one. So an initiation of a dialogue amongst X number of people to just pull this code piece together.
Yep.
So code would be the top of the list. What would you say next is the next piece that you would like?
Near the top, I think it ought to be an agreement to mediate. And most of us have got it in our own separate jurisdictions. And I would be surprised if it's not too different. I mean, frankly, we all borrow from each other. Our English arbitration scheme is bluntly straight taken from the Australian scheme. You can do a word-by-word comparison, mainly because I took the Australian one and adapted it and changed the word Australia, but England and Wales. And so that's the way basically how it came. I suspect an agreement to mediate, because that actually tells the client, what are you entering into? What are you committing to? How can I get out of it, etc., etc. Each of us may then need to have an additional clause that we put in. Ross, and you said, this is an Irish mediation. I've done it through the seat of Ireland. Well, you could put that in as the optional clause. But the bulk of the agreement to mediate was, and that will highlight the outcome, because in it it's most of us say at the end of the mediation I will produce the following documents, or there will be this these are the following possible outcomes, and that will highlight, is it open or is it privileged, because that's going to be again the crunch point. And hey, somebody may say, I don't want to go in England. I've got a choice of going in 4 countries. I can have a mediator in 4 countries. I don't want to go in England because what comes out is privileged. I'd like to know that what I've got is absolutely final. I can rely on it. I can use it as binding according to EU law and whatever. So that's going to be one of the choices. So I think an agreement to mediate or some similar, whatever we want to call it, the opening document. Okay. I wouldn't get too hung up on accreditation, because that is, dare I say, an area where it is ripe for purist differences. I think setting up a scheme like this, you need, dare I put it, the grandfather and grandmother, I hate to use that expression, exemptions. I think you'd start off by saying, right, within various jurisdictions, let's see if we can have a few to put in to start us off, to kickstart a sort of quasi scheme. We're not excluding others. Simply, this is a relatively random sample that we're starting off, and then you say, right, now open it up. What's the entry point for that? And it may well be that it's, I don't know, 5, 8 years. I make it up as I go along. 5, 8 years practice as a mediator, maybe in parallel with another profession, etc. Of which, I don't know, there has been 5 or 6 cases with an international element.
So
open that up and then grow, as it were.
And that leads us to the mechanism, perhaps some sort of international register of mediators. Yeah. Because if you're going to select based on X number of years practicing, then select to what? Put them on a register somewhere. So I think we are talking. Yeah. It may be, and see, okay, so we've got the lis pendens issues within the EU, because there is that rush to seize the forum. Yes. And then we now have England and Wales as another forum within Europe. And then we have, but our families don't think about Europe versus England, Wales versus Africa. They are where they are. They are where they're moving to. Some of the mediation work we're doing, they're actually moving from international forums to other places. So you're having to think about this. So 3 pieces you've got so far: international code, an agreement to mediate that would be agreed to be used with clauses as to the seat of the agreement itself, because certainly from the Irish context, my insurance covers me for mediating in Ireland. It doesn't cover me for mediating elsewhere. So that's why I want to make sure.
That's a problem.
Yeah, but that's why I want to make sure that the agreement to mediate says the mediation is taking place in Ireland, albeit online, but it's you know.
Well, I think that's going to be a problem that we need to address moderately quickly, because lawyers, we're awfully cautious people. And so if I've got an Anglo-Irish dispute as to whether the proceeding should be in England or in Ireland, would I appoint an Irish mediator to deal with a dispute in parallel? But it's an open fact. You go into mediation, it's an open fact. Content privileged in mediation, open fact. And certainly I wouldn't, because they'd say, but you've gone to an Irish mediator. That proves that you're actually, in your heart of hearts, certain that this is in reality an Irish case. Whereas the Irish lawyer on the other side would say, no way am I having an English lawyer for exactly the same. And so we're entering into this realm realm of, I wonder if we ought to go to a mediator from, I don't know, Scotland, so another common law jurisdiction, etc., who would deal with it, as it were, but doesn't say it's either English or Irish. Well, the Scottish mediator is not going to cover insurance because they're two in other places. So that's one of the areas we do get that. We are having that happen in arbitration, where we're having lawyers in two separate countries going to a third country or to a third person, as it were, and saying, we appreciate you're not qualified in either of the two countries, but can you arbitrate? We'll give you a note of the relevant law, but brackets, don't tell too many people, brackets, is actually not too complicated. I'm thinking in terms of property, but in children, it's best interest of the child. That's too easy to say, but there's a lot flowing from it. But there's the essential test. How can we sort it out? Now, that's going on now already, and mediation needs to be able to deal with it and cope with it and say, okay, well, let's have MedArb. Let's have mediation, but with a Scottish mediator. And if it doesn't sort itself out and they can't reach agreement, they'll convert themselves into an arbitrator because, of course, Scotland's got great mediation, great arbitration, etc. They'll convert themselves into an arbitrator if they're convinced by Canada tomorrow, etc. And that's the way I can see that. And that carries huge sorts of insurance issues and professional issues. Under what code am I operating? Well, I would say, Rosanne, you are operating under as an Irish mediator with the Irish code, etc., etc., even if you are doing an Anglo-Scottish dispute.
Absolutely, and I think that's the piece that I put up front, because I've got to be careful about what I'm doing while we figure this all out. The thing is, the clients aren't waiting; they're coming and looking for the solution.
They are.
So this is the interesting thing. So the work is there. So I think what you have now is quite interesting. An international code, agreement to mediate. Let's not worry about accreditation, but we need the grandfather piece.
No, certainly initial lists with badging, so you can see who they are. They'll slap it on the letter heading and all that sort of stuff. So you can say, come to me. There's a marketing element behind all this. Once one starts down that road, I think one's mostly on the way to a launch.
Okay. And I suppose I go back to an earlier piece, because this is, I think, where we're going to finish out our discussion today. And when we finished having the formal talk, we will then have a chat with the people who've logged in and are with us today. But the distinction that's being made between commercial mediation and family mediation. So in Ireland, we have one mediation act that applies to all forms of civil disputes. So we're not distinguishing between commercial and family. And I think actually that's what I prefer, because while there are dynamics in the family mediation that are very, very different to commercial mediation, I think the principles, the fundamentals of training consistency standards should apply across the space. Which is why the Singapore Convention is so disappointing that a family wasn't part of that, because it's all mediation. And many family mediations involve commercial pieces, businesses, and you know, so I think really what we're saying is that we agree, and that we agree that I think we have to start the work. Those of us who are working in this space a long time, have to start the work.
Yes.
David Hodson, thank you so much for talking to me today.
A real privilege, as always.
This is to help our members, and I'm hoping you'll come back and talk to me again someday when we move this a bit further along, and maybe we'll come back to talk about this.
Well, I think we should set an objective. Why can't this be done? Why can't this be launched in a period of, I don't know, what are we, 3 years? Why? I think if we say, oh, it'll be done by the end of the decade, well, we're done by the end of the decade. We'll wait to 2017 to start work. Why can't we say this?
Well, okay, so let's you and I agree. We're in 2022, 24, 25.
End of 25 at
End
the
of
absolute
25.
latest. It will have launched. But I think if it's that time, we will launch with something far bigger.
Okay, I accept the challenge, Mr. Hodson, and you and I and some others will come together and launch this by the end of 2025. And what's going to be funny, this YouTube video will be up there, and let's see, are we going to add one to it to say it's done and we're here? Thank you so much, David. We're going to finish the recording now.
I send all best wishes to everyone in their mediation practice.